I now recognize the gentleman from New Jersey, the ranking member, Garrett, for 5 minutes for his opening statement.
I thank the chairman, and I thank the chair and the members of the committee and the panel and the chairman for holding this important hearing today. I also thank the chairman for all of his hard work and that of his staff as well that they put into this discussion draft. I must begin by saying I'm a little disappointed, as I'm sure the chairman is, that we couldn't find 100% complete bipartisan consensus on all portions of this proposed release. But I do sit here today and pledge to continue to work with the chairman moving forward in hopes that we can eventually reach a place where we both are able to support the eventual final legislation. One of the provisions that the chairman just indicated he has some concerns with deals with the national recognized statistical rating organizations, the NRSROs, and removal of them from the statute. I approached this debate on the credit rating agencies reform with the belief that the two most fundamental problems with our rating system are over-reliance on ratings and a lack of investors' due diligence. Investors have become increasingly, all too often, solely reliant on the use of these ratings in determining the safety and soundness of any investment. In literally hundreds of federal and state government statutes and regulations, there are specific requirements mandating certain grades from the approved agencies. It is this formal requirement that provides an implicit stamp of approval to investors. So when an investor sees that the government is requiring a specific grade to make a safe investment, it reinforces the belief that any investment attaining such a grade is, well, basically safe. Now, I know that the SEC has a similar concern as I do, and so 2 weeks ago, the SEC announced it's removing references to the NRSROs in several of the regulations and studying other areas to determine where else they can be removed. And so I applaud the SEC for their actions, and I urge them to continue with their work. I believe that Congress should follow suit and examine all the areas where statute mandates the ratings of NRSROs. Now, credit ratings are only one piece of the puzzle in determining credit worthiness. Investors must be encouraged to do proper due diligence as well in evaluating issuer credit quality. Now, another way in which I believe we can help increase investor due diligence that this bill does touch on, but does not go far enough, is through increased disclosure through information by the issuer. When dealing with equity securities, investors have all the public information about the company because of the annual and quarterly filing requirements. So I believe that we should require the similar situation with debt securities. The issuer of the debt security should disclose the information contained in the offering more broadly so that investors have the ability themselves to delve deeper into the submitted transaction. While there may be other things included in the proposal that I do support, like increased disclosure, better oversight, there are a couple of provisions that I have a little concern with. The provisions I'm most troubled by center around the question of liability. Unlike many of my friends across the aisle, I do not believe that the solution to all of the solutions to some of these problems of ills is through more lawsuits. And in this case, I do not believe in this case as well. In the discussion draft, there is a provision to institute a collective liability among the NRSROs. And I must say I'm concerned about the practicality of this provision, not to mention the constitutionality as well. I don't see what positive can be obtained by holding all the NRSROs accountable for the actions of just one. Now, the main thrust of the 2006 Reform Act was to increase competition between credit rating agencies. Now, I know that the chairman voted for final passage of that act in 2006, notwithstanding his previously stated belief that there might be a natural oligopoly, as he indicated, within the credit rating industry. If we institute a sharing of financial legal liability, however, between all the NRSROs, I cannot think of any bigger impediment to new entries into the marketplace. Second area of concern regarding legal liability is the language in Section 4 to lower the pleading standards for lawsuits against the rating agencies. By making the rating agencies subject to suits whenever they are, quote, unreasonable, you're essentially lowering the bar from fraud to negligence. The practical effect of lowering the pleading standard will be a dramatic increase in cases being filed and eventually going to court. So I don't believe that having more lawsuits brought against rating agencies is a really constructive way to improve the rating process. Now, Chairman Frank so often noted during the Bush administration that he did not realize that he was here to defend President Bush and his policies whenever there is an argument on the floor of the House with regard to them. Likewise, I must say I did not realize that it would fall upon me to defend President Obama's efforts in this context as well, because the Obama administration has submitted an extensive credit rating agency reform proposal, and increasing legal liability and was nowhere to be found in his proposal. Also, a recent ruling by a federal court judge debunks the myth that it is impossible to get the credit rating agencies into the courtroom. And so we should see how that case plays out before we overreact in committee. I have other concern as well, basically the increased liability. And so while I support the SEC providing better oversight of the NRSROs, I'm worried that too much SEC involvement with rating further implies a government sign-off on the ratings themselves. At what point during the SEC examination process to review whether rating agencies are following their methodologies does the SEC start prescribing specific methodologies for the NRSROs to follow? In my opinion, this would only further the belief that government is doing the rating themselves. Also, the requirement for differentiation of ratings from structured products is a concern. All structured products are not the same, and giving them the same connotation imply that they are. The SEC has already once considered this idea, and they frankly dismissed it after an overwhelming number of investors voiced their concerns. So, in conclusion, I think we all agree that significant reforms for the credit rating agencies are much needed, and I quite frankly do wholeheartedly applaud the chairman for his hard work and again of his staff, and I do look forward to working closely with him and the members of his staff and other members from both sides of the aisle as we move forward on this extremely important issue. With that, I yield back.